Magandang araw po at welcome po sa DriveTruth. Dito po sa segment na tinatawag po nating checkpoint kung saan dinidiscuss po natin yung mga napapanahong mga issues, at isa sa mga napapanahong issue ngayon ay yung Senate Bill number 1083 or yung Anti-Terror Bill. So marami po ang mga nasabi tungkol dito, both from the side ng mga in favor of the passing of this bill and those who are against it. And what I will try to do is to actually just go do a run through ng bill, and I'll try to be as subjective as possible without commenting on whether it is constitutional or unconstitutional. We just want to, my agenda is just to give public information so that people would actually know ano ba talaga yung contents ng bill, sapagkat marami ang nagkokomento, marami ang nagsasalita, marami ang pumapanig o hindi pumapanig nang hindi naman talaga nila nababasa ng buo yung bill. So dito, una nating puntahan would be yung definition of terms. So dito sa paragraph L and M ay define kung sino ang tinatawag na terrorist individual tsaka terrorist organization. So dito, as simple as it is, ang sabi, ang terrorist individual shall refer to any natural person who commits any of the acts defined and penalized under Section 4, 5, 6, 7, 8, 9, 10, 11, and 12. So dadaanan natin yan isa-isa so we could have a better understanding. Section 4 defines acts of terrorism. Actually, merong 5 paragraph, A, B, C, D, and E. And then there is a qualifier kung paano itong mga acts na to would be considered an act of terrorism. For example, letter A is those who engage in acts intended to cause death or serious bodily injury to any person or endanger a person's life. Letter B engages in acts intended to cause extensive damage or destruction to a government or public facility, public place, or private property. Letter C engages in acts intended to cause extensive interference with or damage or destruction to critical infrastructure. Letter D develops, manufactures, possesses, acquires, transports, supplies, or uses weapons, explosives, or of biological, nuclear, radiological, or chemical weapons. And letter E, release of dangerous substances or causing fire, floods, or explosions. But the qualifier is, itong acts A to E would be considered an act of terrorism when the purpose of the said act by its nature and context. Ibig sabihin, dapat i-take into consideration yung nature and context of the act. Nagka-qualify as either to intimidate the general public or a segment thereof, create an atmosphere or spread a message of fear, to provoke or influence by intimidation the government or any of its international organization, or seriously destabilize or destroy the fundamental political, economic, or social structures of the country, or create a public emergency or seriously undermine public safety, shall be guilty of committing terrorism. And the penalty, according to the bill, is life imprisonment without the benefit of parole. But there is also a proviso that says that terrorism, as defined in this section, yung binanggit 8 acts A to E, by their nature and context, it shall not include advocacy, protest, dissent, stoppage of work, industrial or mass action, and other similar exercises of civil and political rights if they are not intended, which are not intended to cause death or serious physical harm to a person or to endanger a person's life or to create a serious risk to public safety. Ibig sabihin, even if we can count it as advocacy, protest, dissent, stoppage of work, industrial or mass action, and other similar exercises of civil and political rights, but it intends to cause death or serious physical harm to a person, to endanger a person's life, or to create a serious risk of public safety, then that may be considered an act of terrorism. Section 5 refers to the threat to commit terrorism. So any person who shall threaten to commit any of the acts aforementioned would be guilty of Section 5, the threat to commit terrorism. Those naman who would engage in planning, training, preparing, and facilitating the commission of terrorism shall likewise be guilty of terrorism. Ang sabi dito, any person who participates in the planning, training, preparation, and facilitation in the commission of terrorism, if you possess objects connected with the preparation of the commission of terrorism, or you are engaged in collecting or making documents connected with the preparation of terrorism, you shall also be guilty of terrorism. Section 7 naman is conspiracy to commit terrorism. So, ang ano naman, as defined by law, ang sinasabi yung conspiracy to commit terrorism is when two or more persons come to an agreement concerning the commission of terrorism and they decide to commit the same. Well, that's very similar to the definition of conspiracy with regard to crimes defined under the revised penal code. Section 8 talks about the proposal to commit terrorism, so even the mere proposal to commit terrorism. Section 9 would be inciting to commit terrorism. So, I think this is one of the contentious provisions because according to Section 9, any person who, without taking any direct part in the commission of terrorism, shall incite others to the execution by means of speeches, proclamations, writings, emblems, banners, or other representations tending to the same, shall suffer the imprisonment of 12 years. Ibig sabihin that is considered already inciting to commit terrorism. Section 10 speaks about recruitment to and membership in a terrorist organization, while Section 11 speaks about foreign terrorists. Section 12 speaks about providing material support to terrorists, and there is a definition of what material support is under the definition of terms. But for lack of material time, we'll just skip that. We'll go doon sa isa pang contentious provision, which would be this surveillance of suspects and interception and recording of communication. So dito ang sabi, notwithstanding the anti-wiretapping law, any law enforcement agent or military personnel may, upon a written order of the Court of Appeals, secretly wiretap, overhear, and listen to, intercept, screen, read, surveil, record, or collect with the use of any mode, form, kind, or type of electronic, mechanical, or other equipment or device or technology now known or may hereafter be known to science, or with the use of any other suitable ways and means for the above purpose, any private communications, conversation, discussions between members of a judicially declared and outlawed terrorist organization, between members of a designated person as defined in Section 3E of Republic Act 10168, and any person charged with or suspected of committing any of the crimes, provided that surveillance, interception, recording of communications between lawyers and clients, doctors, patients, journalists, and their sources, and confidential business correspondence shall not be authorized. So dito, the possibility of surveillance dun sa mga suspected na mga terrorist individuals, designated terrorist individuals, or designated terrorist organizations, terrorist groups, shall be with the written order of the Court of Appeals. Now, ano naman yung mga pamantayan for the issuance of a judicial authorization? Now, the procedure is that the law enforcement agent or military personnel shall be obligated to file an ex parte application with the Court of Appeals. This is in relation to compelling telecommunication service providers, TSPs, and ISPs or internet service providers. Now, dito, there is a requisite. May mga requisites for judicial authorization. So, it's the filing of an ex parte written application by the law enforcement, but the personnel should be duly authorized in writing by the Anti-Terrorism Council, which means the Anti-Terrorism Council would first give a written authorization to law enforcement or military personnel, and then that military personnel or law enforcement agent can prepare a written application, ex parte written application. Ex parte meaning even without informing the other party. Now, after the examination under oath or affirmation of the applicant and the witnesses, he may produce the issuing court. The issuing court determines if there is probable cause, so there should be probable cause, and that is a judicial finding by the Court of Appeals based on personal knowledge of facts or circumstances in relation to Section 4.5. Ibig sabihin, is there an act of terrorism? Meron bang conspiracy? Meron bang proposal? Meron bang planning? So, yun yung mga probable cause. And that the probable cause is believed to be based on personal knowledge of facts or circumstances, that the evidence which is essential to the conviction of any of the charged or suspected person or to the solution or prevention of any of such crimes that will be obtained. So you are applying for the ex parte written application should not only highlight probable cause, but then that whatever would be recorded, whatever would be wiretapped, whatever would be surveilled, would actually be essential to the conviction of the persons. Now, dito, ang sinasabi, under Section 18, ang sabi dito, it's classified information. So, whatever is collected would be considered classified information. And then, one more contentious portion of this provision is the effective period of judicial authorization. Ang sabi kasi dito, any authorization granted by the Court of Appeals pursuant to Section 17 shall only be effective for the length of time specified in the written order of the authorizing division of the Court of Appeals, which shall not exceed a period of 60 days. So, ibig sabihin, one time, the Court of Appeals can issue a judicial authorization good for a maximum period of 60 days. Now, according to some people, yan yung medyo contentious, why 60 days? And is a shorter period not valid? But I think that would be a policy question of whether or not a shorter period would be sufficient in order to gather information. Now, the next na dito na contentious provision, but I will also highlight this, yung custody of whatever is intercepted and recorded, merong guidelines provided ng batas in how it would be kept. Ang sabi dito, within 48 hours after the expiration of the period fixed in the written order or the extension or renewal granted thereafter, the whatever is collected should be deposited with the issuing court in a sealed envelope or a sealed package as the case may be, and shall be accompanied by a joint affidavit of the applicant, law enforcement agent or military personnel, and the members of his team. So that's how these things would be kept, and it's considered classified information. So, yan yung with regard to surveillance and the collection of recorded data. So, whether that be voice or wiretap conversations, yan yung magiging niyan. And then, there's a provision that says that whenever the collected data is unauthorized or it's a malicious interception, the law enforcement agent or military personnel who conduct surveillance activities without a valid judicial authorization shall be guilty of this offense and shall suffer the penalty of imprisonment of 10 years. So, yun naman yung parang counter-balancing na provision just to ensure that the law enforcement agent or military personnel would not abuse, or as much as possible, if they would wiretap and they would like to introduce it into evidence, it should be with prior judicial authorization. Now, let's go forward to another contentious provision, which is yung detention without judicial warrant, which is Section 29. Now, dito ang sabi, the provisions of Article 125 of the Revised Penal Code to the contrary notwithstanding, any law enforcement agent or military personnel who, having been duly authorized in writing by the ATC, has taken custody of a person suspected of committing any of the acts defined, should deliver said person to the proper judicial authority within a period of 14 days. Now, what is Article 125 of the Revised Penal Code? This is the provision of the Revised Penal Code that tells law enforcement agents in cases of warrantless arrests, that they have a certain period to comply with, na dapat madala nila yung person na yon, yung suspect na yon, to the proper judicial authorities. Under the revised penal code, that would be 12, 18, and 36 hours, depending on the gravity of the offense. So we have light offenses and we have grave offenses. So the longer period would be for grave offenses, and then the shorter period would be for light offenses. But for this particular provision of law, if this would become a law, ang sinasabi dito, if you are suspected of terrorism and you are arrested without a warrant, the law enforcement personnel, the law enforcement agent or military personnel, has a period of 14 days to hold you without bringing you to the proper judicial authorities. And that period of detention may be extended to a maximum period of 10 calendar days if it is established that further detention of the person or persons is necessary to preserve evidence related to the terrorism or complete the investigation. Number 2, further detention of the person or persons is necessary to prevent commission of another terrorism. And number 3, the investigation is being conducted properly and without delay. So, ibig sabihin, once a person is taken, but before that, before a person may be detained or arrested without judicial warrant, it's said that the law enforcement agent or military personnel should be duly authorized in writing by the ATC. Later, we will try to discuss sino ba yung mga but preliminarily, the members of the ATC would actually be executive members of the different departments. So you have the executive secretary, I believe, if I'm not mistaken by memory, the Secretary of Justice is there, the Secretary of Finance, and other secretaries ng executive department na bumubuo ng council na yon. And the secretariat would be the National Intelligence Coordinating Agency, which means most probably the application for a written authorization for the arrest of individuals or groups or organizations would come from the secretariat. So with the approval of the council, the secretariat would issue a written authorization, and the military personnel or law enforcement agent can then, under normal circumstances kasi, when you arrest a person, you apply for a warrant of arrest. And a warrant of arrest, there should be a finding by the judge personally that there is probable cause. So in this case, there is still probable cause, but then the issuance of the written authorization is not by the judiciary, it's not by the judge, it's not by a court, but it's by the Anti-Terrorism Council. So, yun yung difference niya. Now, the period of detention naman is, the general rule is you can be detained for 14 days. It can be extended under itong sinasabi kong mga pagkakataon, 1, 2, and 3. It can be extended to another period of additional 10 days, bringing it to a total of 24 days. Now, ano naman yung procedure right after your arrest? It's called, parang the law calls it custodial detention. So sabi dito, immediately after taking custody of a person suspected of committing terrorism, dapat the law enforcement agent or military personnel shall notify in writing the judge of the court nearest the place of apprehension. Now, what is the period? Is it within 3 hours, 5 hours, 7 hours, 12 hours? Ang sabi ng batas, it's immediately after taking custody. So, what can be immediately after taking custody is a matter of fact. So, can it take 36 hours, for example, kung masyadong matagal yung period? Could be. So, ito lang siguro yung isa sa mga, without pointing my own prejudice or bias, diba? I'm just pointing out na there is no period provided. The law just says immediately after. So, after being detained, after being taken into custody, the law enforcement agent or the military personnel should notify in writing the judge. And the following facts should be included in the notice: the time, date, and manner of arrest. Kasi nga, it should be determined kung lalagpas na ba ng 14 days, Letter B, the location or location of the detained suspects, the physical and mental condition of the detained suspects. Now, the question is, since the judge is notified immediately after, does it count, for example, if you were arrested and then for whatever circumstances, the law enforcement agent or military personnel, for example, could not notify the judge? For example, may bagyo, sarado, or there's an enhanced community quarantine, for example, and until the period that the court reopens, they could not notify the judge. Would your arrest start from, or would the counting of the period start from the actual notification or from the actual arrest? I think it's answered by the fact na the judge should be notified of the time, date, and manner of arrest. So, ibig sabihin, dapat yung period of counting should still be counted from the actual time of arrest. Now, there is also a penalty for law enforcement agents and military personnel who would violate yung mga provisions na ito. And sabi dito, the penalty of imprisonment of 10 years shall be imposed upon the police or law enforcement agent or military who fails to notify any judge as provided in the preceding paragraph. Now, there are rights provided for a person under custodial detention. Ano yung mga rights na provided dyan? Sabi, he should be informed of the reason kung bakit siya inapprehend or arrested. He shall be informed of his right. He shall be informed of the nature and cause of his arrest. He shall be informed that he has the right to competent and independent counsel, preferably of his choice. If the person cannot afford the services of counsel, the law enforcement agent or military personnel is obliged to immediately contact the Free Legal Assistance Unit of the Integrated Bar, the Public Attorney's Office, and it shall be the duty of the Free Legal Assistance Unit of the IBP and the PAO to immediately visit the person detained. And sabi, these rights cannot be waived except in writing and in the presence of his or her counsel. So ito yung mga rights if ever you are detained, if you are arrested without a warrant in relation to acts of terrorism. Now, so you will be allowed to communicate freely with your counsel. You will be allowed to communicate freely and privately without restrictions with members of your family or nearest relatives, and you can be visited by them. You can be allowed to freely avail of the services of a physician or physicians of choice. Now, in case there would be violations of the aforementioned rights, ang sabi dito, the penalty of imprisonment of 10 years shall be imposed upon any law enforcement agent or military personnel who has violated the rights of persons under their custody as provided for in Section 29 and 30. Okay? Now, there is also a official custodial logbook defined by law. So, the law enforcement custodial unit, kung saan dinala yung person na yon, should keep a securely and orderly maintained official logbook, which is hereby declared a public document and open to and made available for the inspection and scrutiny of the lawyer, of the persons under custody, or any member of his or her family or relative by consanguinity or affinity within the fourth civil degree. So, before, if a person is extrajudicially arrested, what happens is that the lawyers would file a writ of habeas corpus to compel law enforcement or military facilities to actually declare if yung person suspected is actually in their detention. So in this case, hindi na kailangan na ganun because there is a custodial logbook. So yung custodial logbook should have the information available and should be opened and made available to the lawyers, to members of his or her family. So yan yung mga provisions nung ano. So ano yung contents ng custodial logbook? So the name, description, and address of the detained person, the date and exact time of his or her initial admission, the name and address of the physician or physicians who examined him or her physically and medically, the state of his or her health and physical condition, the date and time of each removal of the detained person from his or her cell for interrogation, date and time of his or her return to his or her cell, the name and address of the physician or physicians who medically examined him or her after each interrogation, A summary of the physical and medical findings on a detained person after each of such interrogation, names and addresses of his or her family members and nearest relatives, if any and if available, the names and addresses of persons who visited the detained person, the date and time of each visit, the date and time of each request of the detained person to communicate and confer with his or her legal counsel or counsels, the date and time of each visit and date and time of each departure of his or her legal counsel or counsels, all other important events bearing on all relevant details regarding the treatment of the detained person while under custodial arrest and detention. So, yan yung mga information na I think medyo comprehensive naman. There's even a need to, for the examination, so after interrogation, pag bumalik, there should be a examination of the detained person by a physician just to ensure na walang nangyaring any form of abuse or any form of torture or coercion. So, yung violation din neto, if the law enforcement custodial unit fails to comply, the imprisonment of 10 years is also applicable. So, Section 33 naman tells you that there should be no torture or coercion in the investigation or interrogation. Now, isa pa na medyo contentious dito would be this restriction of the right to travel. So, previously, we have the idea of a whole departure order or that a person out on bail, for example, is restricted of his right to travel and he would have to inform the court. Pero in this case, the investigating prosecutor can apply for the issuance of precautionary whole departure order against the respondent upon preliminary determination of probable cause. Now, upon the filing of information regarding the commission, so once the information is filed in court, the court having jurisdiction would have to determine whether there is sufficiency or there is ground to issue to make permanent the precautionary whole departure order or to remove it. But the questionable provision here would be, ang sabi dito, when you are entitled to bail, in cases where evidence of guilt is not strong, and the person charged is entitled to bail and is granted the same. Kasi bail is a matter of right. So everybody has a right to bail except for certain cases, certain crimes that are non-bailable. But even for non-bailable crimes, if the evidence of guilt is not strong, you can apply or you can petition the court for bail. Now in this case, baligtad naman. Sinasabi dito, in cases where the evidence of guilt is not strong, and the person charged is entitled to bail. Ibig sabihin, the evidence that the prosecution is currently holding is not strong, and the court finds that you're entitled to bail. Ang sabi dito, the court, upon application by the prosecutor, shall limit that right to travel of the accused to within the municipality or city where he or she resides or where the case is pending, in the interest of national security and public safety. So, travel outside of the said municipality or city without the authorization of the court shall be deemed a violation of the terms and conditions of his or her bail, which shall be forfeited as provided under the rules. So, dito medyo parang baligtad. So, technically, if you're out on bail under crimes punishable under the revised penal code, you're allowed to travel. Unless your travel is abroad, then you would have to secure a written authorization from the court. Pero in this case, even when the evidence of guilt is not strong and you are out on bail, this law seeks to limit your right to travel to within the city or municipality where you reside or where the court is actually located. So, yun yung pinagkaiba niya dito. Pag ganun yung nangyari, he or she may be placed under house arrest by order of the court at his or her usual place of residence. While under house arrest, he or she may not use telephones, cell phones, emails, computers, the internet, or other means of communication with people outside the residence until otherwise ordered by the court. So, yun yung ano dun. So, if the evidence of guilt is strong naman, the court shall immediately issue an HDO and direct the DFA to initiate the procedure for the cancellation of the passport. Balikan lang natin, no, ito yung magiging composition ng Anti-Terrorism Council. It would be chaired by the Executive Secretary. The National Security Advisor would be the Vice Chairperson. The Secretary of Foreign Affairs is a member, Secretary of National Defense, Secretary of Interior and Local Government, Secretary of Finance, Secretary of Justice, Secretary of Information and Communications Technology, and then the Executive Director of the Anti-Money Laundering Council. Of course, NICA would be the Secretariat of the ATC. Isa pang importanteng balikan nating provision would be yung designation ng terrorist organizations and the prescription of terrorist organizations or terrorist groups. So, if I'm not mistaken, that would be under Section 25, is the designation of terrorist individual groups or of persons, organizations, or associations. So, it says here that we shall adopt the UN Security Council Resolution number 1373, which states kung sino yung mga designated na mga terrorist organizations internationally, and that yung UN Security Council consolidated list of designated individuals, groups of persons would be adopted by our country. Now, the request for designations by other jurisdictions may be adopted by the ATC, but here, the ATC is given the power to designate an individual, groups of persons, organizations, or associations, whether domestic or foreign, upon a finding of probable cause that the individual, groups of persons, organization, or association commit or attempt to commit or conspire in the commission of the acts defined and penalized under yung sections 4, 5, 6, 7, 8, 9, 10, 11, and 12. Now, resultant to that would be the assets of the individuals may be subject to a freeze order by the Anti-Money Laundering Council. And sabi dito, the designation shall be without prejudice to the proscription of terrorist organizations, associations, or groups of persons under Section 26. Now, ano yung difference, what would be the difference of a designation and the prescription which is done by the court? Because it seems like if the ATC may designate an individual, or groups of persons, an organization or association, that is an executive finding based on probable cause. Now, if it's done, I think that would be sufficient to issue a written order for the warrantless arrest of certain individuals who are suspected or who are alleged to be committing or to be in conspiracy or who is proposing acts of terrorism as defined by the previous sections we have discussed. Now, Section 26 is proscription of terrorist organizations. So this is a judicial finding. So dito, any group of persons, organization, or association which commits any of the acts, as aforementioned in Section 4 to 12, or organized for the purpose of engaging in terrorism, shall be, upon application of the DOJ, before the authorizing division of the Court of Appeals, with due notice and opportunity to be heard given to the group, be declared as a terrorist and outlawed group of person, organization, or association by the said court. So, the designation by the ATC is an executive finding. The order of proscription is a judicial finding. How it really works and differs isn't clear right now kasi I think if you are designated by the ATC, the written orders, that could be the basis for an ex parte application, written authorization for wiretapping. That could be a sufficient basis for warrantless arrest. And ito kasi, it's a judicial finding. So if the DOJ finds that there is probable cause, it finds that certain groups or groups of individuals are organized for the purpose of engaging in terrorism, the DOJ may apply before the authorizing division of the Court of Appeals that a group, an organization, an association be declared as a terrorist and outlawed group of persons or organizations. Now, the application shall be filed with an urgent prayer for the issuance of a preliminary order of proscription. No application for prescription shall be filed without the authority of the ATC upon the recommendation of the NICA, or the National Intelligence Coordinating Agency. So pursuant to that, a preliminary order of prescription may be issued when the court determines that there is probable cause, and on the basis of the verified application that is sufficient in form and substance, the order of prescription may be issued. Now, if it's necessary to prevent the commission of terrorism, it works like a TRO, and it shall be within 72 hours be issued from the filing of the application. It shall declare that the respondent is a terrorist and an outlawed organization. The court shall immediately commence and conduct continuous hearings, and then it should be completed within 6 months, and then the court should either order the preliminary order be made permanent, or issue a permanent order in case there was no preliminary order issued, or the preliminary order should be lifted. So yun yung mga prescription. So there's also a provision as to request to prescribe from foreign jurisdictions and supranational jurisdictions. Ang sabi dito, consistent with the national interest, all requests for prescription made by another jurisdiction or supranational jurisdiction shall be referred to the Department of Foreign Affairs, to the ATC, to determine with the assistance of NICA if prescription under Section 26 is warranted. If the request of prescription is granted, the ATC shall correspondingly commence prescription proceedings through the DOJ. So it's up to the Department of Foreign Affairs. For example, a foreign jurisdiction, a foreign country, another state would request that a certain organization present in their country, they find that the same would have material support coming from the Philippines, or they are recruiting in the Philippines, then they can request the Department of Foreign Affairs, the ATC, and with the assistance of the NICA, if a application for prescription should be done by the DOJ. So, yan yung mga medyo questionable na provisions dyan. I will no longer discuss the authority to freeze kasi even currently I think the AMLA can actually order for the freezing of certain accounts related to certain crimes, like for example drugs, or in this case terrorism. So yun lamang po. I hope I was able to somehow give light to certain provisions, mga contested provisions. I leave your decision to find it. Is it something humane or inhumane? Is it constitutional or unconstitutional? I leave it up to you. You can comment down below and leave me your comments so we could discuss. But my primary purpose in doing this is to only shed light in accordance with the provisions of the law or provisions of the bill, and to just give a basic understanding kung ano ba yung sinasabi ng batas regarding these certain provisions. Maraming salamat po. Magandang araw po sa inyong lahat. Pagpalain po kayo ng Diyos. At kung gusto niyo po ng mga gandang videos, huwag niyo po kalimutan mag-subscribe sa aming YouTube channel, DriveTruth, at ganyan din po sa aming Facebook page, DriveTruth. Maraming salamat po. Pagpalain po kayo ng Diyos.